avoir de problème de résonance Ok, d'accord. Parce qu'on a rencontré un peu ces problèmes-là dans d'autres moments, donc j'ai un peu peur de ces questions. D'accord, parfait. Les deux sont allumés.
Assieds-toi quelque part à côté, comme ça tu auras les possibilités de soulever et aller au.
Thank you. Welcome everybody, dear friends, dear students, dear all. It's a real pleasure to see you all, the ones already that we saw on Monday for the inaugural lecture, the first special event, which was sponsored already, and tonight also for the second special event, which is sponsored in fact by the Descartes and Sherman Sterling law firms. They are long time friends of the Academy, and that's a very nice support, and many thanks to them. This is the second special event tonight, Goldman Lecture, and we came to listen to Salim Moollan QC, which I introduce very soon. And I remind you also that there will be a third special event this year, because we are launching for the first time the Emmanuel Gaillard debate in memoriam of Emmanuel, who passed away 1 year ago. And it will be a debate between Professor George Berman from NYU and Dr. Iyas Bani-Fatemi. And thanks to the nice support of GBS Disputes, it's going to take place along the Seine on a boat on Tuesday next week, 12th of July. We are very grateful tonight to Salim Moollan to come and give his lecture despite a very busy schedule. And it's a great honor and a great joy to welcome him on behalf of the Arbitration Academy for the 2022 session. I would like, even though I did it already during the inaugural lecture, I would like to thank my teammates, the teammates of the board of directors, Christophe Seraglini, Karine Duperron, and Nadia Darwazé, as well also as Pierre Meyer, former president, and all the members of the board of the executive committee. To introduce Salim, it will be very easy. You know him, or most of you know him even a lot. In many ways, his education, his career, his professional activities are unique, various, and totally amazing. Leaving his Mauritius a long time ago, it's a very nice Mauritius island. He was educated in Paris at Louis le Grand, graduated from Polytechnic in Paris, mathematics and physics. You could have been at home almost on Monday. That was at Maison des Polytechniciens. He decided after to attend Cambridge Law School, got a degree in law, of course, and then, because it was not sufficient for him, started to do economics and political science, and got graduated from Sciences Po to embrace finally the legal field with what a success. Salim is very well known. He's a very well known QC. He's a talented barrister since 1998, and also a foreign lawyer registered to practice in Singapore. He specialized in international and commercial law, and of course, in particular, international investment and commercial arbitration. He has acted as counsel in high-profile investment arbitration cases, as well as commercial cases, and currently acts as legal counsel, lead counsel, in a number of prominent investment arbitration for both states and investors. He acts also in the commercial field in general, in high-value cases, in particular in the energy and telecom fields, and acts frequently also, since his schedule is not busy enough, as arbitrator, party appointed or chair, in investment and commercial arbitrations. I have to say also that Salim got talent for a lot of things. He has also in-depth knowledge of the procedural regimes of all major international arbitral institutions, and he has been a past, and I will just do a quick summary. He has been a past chairman and vice chairman of Cercle, a past vice president of the ICC Court, a past member of the LCIA Court, a member of the World Bank ICID Panel of Arbitrators, and a former editor of the ICID Law Review. Salim has also been retained by the Mauritian government to advise and assist in drafting the new Mauritian International Arbitration Act, which is very interesting, as you know, and which was enacted in 2008 and came into force on 1 January 2009, and is a representative of the Mauritius state as the United States Commission on International Trade Law and Cercle since 2006, and acts also as ICC Africa ambassador. He's also visiting professor of international arbitration law at King's College, University in London. We are very honored and pleased to welcome Salim tonight for the Goldman Lecture. Salim is going to speak about a very well-known case, at least for the arbitration world, bringing some interesting issues between two different places of arbitration, London and Paris, in relation, notably, with the recognition and enforcement of an international award. The title of his lecture, as you can see, is A Tale of Two Cities, l'affaire Dallah. Salim, many thanks again. You have the floor.
Merci, Daniel. It was the best of times. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the epoch of belief. It was the epoch of incredulity. It was the season of light. It was the season of darkness. It was the spring of hope. It was the winter of despair. Thus commences Charles Dickens' Tale of Two Cities, London and Paris, the seats of two great cultures, so similar, yet so distant. It seemed to me that Dickens' work and these opening words were an apposite introduction to the historic case which I'm here to discuss today, Dallah Real Estate and Tourism Holding Company and the Ministry of Religious Affairs, Government of Pakistan. A tale, as we shall see, of differing legal cultures and of passions unleashed on both sides of, I think it's called the English Channel. As is customary for the Goldman Lecture, I shall begin by a narrative part covering the history of the case in the arbitration and before the courts of England and France. I will then turn to the legal analysis of the two key legal issues in the case, the standard of review on challenges on jurisdiction and the question of applicable law to the arbitration agreement. I will spend more time on the latter, for it raises important issues of theory and practice. I will conclude by looking in conclusion at the unspoken substratum of the case, unspoken by the courts, but immediately seized upon by all commentators on the case, that is, the divergence of legal cultures in the two jurisdictions. Before I start, I would like to thank Mr. Ali Adamji for all his help in the preparation of this lecture. The research was his, but the views and mistakes are mine alone, of course, and also the board of the Academy for inviting me to deliver this lecture. Let's start with the narrative. A decision taken by the Pakistani cabinet in December 1994 on a cool winter day in Islamabad and implemented by President Farouk Leghari under the Bhutto government just over a year later would lie at the heart of what has become one of the most celebrated cases of recent times on the consent of non-signatories to arbitration. The decision relates to the establishment of a trust, the Awami Hajj Trust, for the purpose of the organization of the Hajj for pilgrims from Pakistan. As many in the audience will know, the Hajj is the pilgrimage to the holy city of Mecca, which every adult Muslim must make at least once in his or her lifetime. In fact, and as coincidence would have it, as I'm addressing you, the Hajj has begun today and is currently taking place in Mecca. Pakistan has the second largest Muslim population behind Indonesia and wished to acquire land in Mecca to construct housing for 45,000 Pakistani pilgrims performing the Hajj. Dallah is a Saudi Arabian property group. In early 1995, Mr. Naqvi of Dallah approached the Pakistani government and proposed that Dallah be permitted to provide the government of Pakistan with a housing complex in Mecca or Medina on a long-term lease for use by Pakistani pilgrims. From March to April 1995, discussions ensued. Those led to an announcement in May 1995. On the 24th of July of that year, Dallah and the President of Pakistan, through the Ministry of Religious Affairs, MORA, concluded an MOU pursuant to which the government of Pakistan recorded its interest in taking the necessary property on lease, and Dallah, conversely, agreed to acquire the necessary real estate, construct the required structures and buildings, and lease those to the GOP. The governing law of that MOU was Saudi Arabian law. It had an arbitration clause, but with a seat in Jeddah. On the 17th of August of that year, 1995, Mr. Naqvi of Dallah sent proposals in respect of the lease and financing of the project to a Mr. Lutfullah Mufti. Now remember that name, because Mr. Mufti will in due course come to wear two hats, and that's going to make quite a difference in this case. On the 18th of November, still of 1995, Dallah acquired land in Mecca, but the government of Pakistan did not approve the financing and lease proposals within the 90 days after they were sent to it on the 17th of August 95. So on the face of the MOU, that was the end of that particular document. The trust was created by promulgation of an ordinance on the 31st of January of 1996. The ordinance provided, inter alia, that the trust would be a body corporate, having perpetual succession, with power to acquire, hold, and dispose of property, and to sue and be sued in its own name. And, importantly, that the Secretary of the Ministry of Religious Affairs, Mr. Mufti, would be a member of the board and also act as the trust secretary. On the 14th of February 1996, the trust was formally established following notification by MORA in the official gazette. Now, there is a particular feature of Pakistani law which turned out to be of key importance to the case. Under Article 89(2) of the Constitution of Pakistan, unless adopted by legislative act, ordinances will automatically lapse if they are not renewed every 4 months. The trust, being a creature of the ordinance, therefore depended on successive renewals every 4 months for its continued existence. The ordinance was renewed twice, first on the 2nd of May 1996, and then on the 12th of August 1996. But matters were then to turn for political reasons. On the 10th of September 1996, Dallah and the trust entered into the agreement, which is the subject of this lecture, which gave effect to the intention of the Pakistani government to construct housing for its pilgrims performing the Hajj. We've put on the next slides 4 and 5 the text of the agreement, or rather points from the agreement. The previous slide you will have seen. Previous slide, please, Ali. Thank you. The main clauses, which are as expected. Perhaps of more interest is the slide we were on, so slide 5, which is the arbitration clause, clause 23, which I will leave you to read. ICC Paris, 3 arbitrators. And clause 27 permitted assignment to the government of Pakistan without the need for Dallah's consent. In the early hours of the morning of the 5th of November 1996, a major political event took place in Pakistan. Ms. Bhutto was ousted, and Mr. Malik Mehraj Khalid was appointed caretaker prime minister. Now, the ordinance creating the trust had last been renewed, as I told you a moment ago, on the 12th of August 96. For the trust to subsist, it would have had to be renewed on or before 11th of December 96. It was not. And the trust was no more. This point was not in dispute between the parties. Both Dallah's and Pakistan's experts on Pakistani law in the English High Court were agreed that as a matter of Pakistani law, the trust lapsed at midnight on the 12th of September 1996, and that the trust ceased to exist as a legal entity. This was a matter of puzzlement for Mr. Justice Aikens, the judge who heard the case at first instance in England. He said this at footnote 5 of his judgment, and I see that Ali was ahead of me and has already put it there, but he marked puzzlement. And it is puzzling. It's not something I will have time to cover in any detail tonight, but maybe we can discuss it later. There are so many angles to this case. But the idea that a body corporate vanishes into thin air with no law of succession is a very weird one, and I think something which would have been worth pushing further in terms of Pakistani law. And you can see from what Mr. Justice Aikens says there that if only Dallah had pushed a bit, he would have grabbed that perch with both hands. Now, going back to the chronology, the next step after the coup and the lapse of the trust is an important one. On the 19th of January 1997, Mr. Mufti wrote a letter to the chairman of Dallah. Under the letterhead of the Government of Pakistan, Ministry of Religious Affairs, so government letterhead, signed as secretary without any indication as to which organization. I think we can stay on the previous slide, please, Ali. We change as we go. You will remember that Mr. Mufti wore two hats. He was the secretary of Mora, of the ministry, but he was also the secretary of the trust. But he simply signs as secretary on government letterhead. This letter became a key piece of evidence before the Arbitral Tribunal, the English courts, and the Paris Court of Appeal. As we shall see, the interpretation and weight afforded to it, however, differed considerably before the Arbitral Tribunal and the Paris Court of Appeal on one hand, and the three English courts on the other hand. The letter asserted that Dallah was in repudiatory breach of the agreement, and that the agreement had either not become effective or had come to an end as a result of that breach. The day following the letter, on the 20th of January, the trust applied to the Pakistani courts in Islamabad to seek declaratory and injunctive relief against Dallah. I will not cover the ensuing Pakistani proceedings in detail for lack of time. What I would like you to note in that respect is that the first set of Pakistani proceedings commenced on the 20th of January, so the one I've just referred to, were commenced in the name of the trust. The plaint was signed by Mr. Mufti and supported by sworn evidence from him in the name of the trust. What was sought to be litigated before the courts of Pakistan was the alleged termination of the agreement. Those proceedings were dismissed by the Pakistani courts about a year later, on the 21st of February 1998, on the basis that government had succeeded the trust. So the Pakistani judge said, if you've got the wrong entity, you no longer exist, government should sue. Having opposed the first set of proceedings on the basis that the parties had agreed to ICC arbitration, Dallah, of course, starts ICC proceedings. It does that on the 19th of May 1998, and we'll, of course, come to that in a moment. In response, Pakistan takes the prompt of that first Pakistani judge and starts proceedings, identical proceedings, but this time in the name of the government. That was dismissed on the 18th of September by another judge on the basis that the GOP was not a signatory of the agreement and that Dallah had not put forward any evidence that the agreement had been assigned to the government of Pakistan under that clause I showed you earlier, clause 27. So one judge says you should be suing, the next judge says you can't sue. Those proceedings are then withdrawn by Pakistan, and a third set of proceedings started again to try and get a declaration and injunction from the Pakistani courts. That's again dismissed by the Pakistani courts, this time on the basis that the government of Pakistan has no locus standi to get any declaration as to the agreement. So that's what happens in Pakistan. Now, turning to the arbitration, as I have just noted, Dallah's request for arbitration was filed on the 19th of May 1998. You can see on the next slide what it is they claimed for, which is as you would expect. The claim, of course, was started against Pakistan, the trust no longer being in existence. By this time, Pakistan is busy pursuing all these injunctive relief proceedings in Pakistan. And in the words of Mr. Justice Aikens, took very limited part in the ICC arbitration. On the 15th of August 1998, the Ministry of Religious Affairs wrote to the ICC, stated it would not submit to the jurisdiction of the International Court of Arbitration because there was no contract or arbitration agreement between Pakistan and Dallah. The ICC court, of course, nonetheless proceeded with the constitution and appointment of the three-member arbitral tribunal under clause 23 of the agreement. Dallah's appointee to the tribunal was Lord Mustill, to the left. The appointee of Pakistan in default made by the ICC was Mr. Justice Dr. Nasim Shah, and the tribunal was chaired again by ICC appointment by Dr. Khaleb Mahmasani. Let me say a brief word about each of them, and hopefully giving you angles that not everyone has picked up on. Dallah's nominee was one of the most distinguished English judges, a retired law lord known both in England and France for his erudition in international arbitration. Lord Mustill was actually a Cambridge mathematics graduate who converted to law and was one of the founding members of my former professional home, Essex Court Chambers. He was the distinguished author of Mustill and Boyd on commercial arbitration, and he was also the UK delegate to UNCITRAL. He played an important role in the drafting of the Arbitration Act, and perhaps uniquely for a common lawyer in those days, studied and wrote about the Lex Mercatoria extensively. He was therefore no stranger to the transnationalist approach to international arbitration and was familiar with the Dijon school of thinking. Dr. Shah was a former Chief Justice of the Supreme Court of Pakistan. He took a first in law from the University of the Punjab in Lahore, nothing unexpected perhaps there. But interestingly, and perhaps not known to many, he pursued his academic studies in France, where he went on to obtain 2 doctorates, one in jurisprudence, the other in political science, both with mention très bien from the University of Paris-Sorbonne. Dr. Shah was also the nominee of Pakistan to the Permanent Court of Arbitration in The Hague from 1959 all the way to 1977. So contrary to the observations of some commentators on the Dallah case, Dr. Shah could thus not be said to have been a pure product of the common law. Dr. Mahmasani, the chairman, was a highly distinguished Lebanese lawyer. He read law in Beirut, obtained a doctorate from the University of Lyon, and was also a member of the Permanent Court of Arbitration in The Hague from 2000 to 2005. As Desalé and Garth would put it later, 3 grand old men of arbitration. At a hearing on the 26th of March 1999, the tribunal set the seat of the arbitration as Paris. The GOP, of course, refused to sign the terms of reference, and the tribunal decided to bifurcate the proceedings. On the 26th of June 2001, it rendered the award, which was going to be at the center of all the litigation, a unanimous first partial award on jurisdiction. The FPA is not publicly available, but passages thereof are extensively quoted in the judgment of the UK Supreme Court. I will stop to just note that I think that the omerta on the award should now cease. I think enough time has lapsed. I think perhaps the ICC could take the step of redacting confidential information and making this very important award public. I don't think it's normal that someone like me, or indeed anyone else, with academic interest in the field should still be deprived of access to the award. Just my personal view, but I do think that's important. Now, turning back to what the FPA says from what we know, and it is, again, extensively quoted in the Supreme Court judgment. On applicable law, the tribunal rejected, and you've got the full quote of their reasoning, which you must have read about already in commentary. It's quite well known. Their reasoning on applicable law, where they referred to Dalico, decided that they would not apply a national law, but instead transnational general principles, meeting the fundamental requirements of justice in international trade. And you will see from the quote that Dr. Shah and Lord Mustill went along with that with some reluctance. And they say it doesn't make a difference to the results, so fine. Now, the next slide is very important. That sets out the test which was applied by the tribunal. And you will see two things in particular, which I would like you to note. First, that this test is clearly derived from French case law. Indeed, it is public knowledge, albeit not recorded in any publicly available material, that the tribunal had raised the relevant French case law proprio motu shortly before its award was issued, inviting comments from the parties. So effectively a test based on French case law. Secondly, and that is important, it is framed, as you can see, as an objective test based on the implication of the third party in the transaction, not a subjective test based on a search for common subjective intention. See the words that we have highlighted in bold. Now, I don't have the time in this lecture, obviously, to do justice to the tribunal's detailed factual analysis, nor indeed to that conducted by each of the four courts that would then come to consider the award. I will focus on their main conclusions and would direct you instead to the excellent article written by, I can't see him now, but by Jacob Grierson and Ms. Tauk in the Journal of International Arbitration. There he is. Excellent article, which also very helpfully annexes a table which analyzes the judgments of the tribunal and the four courts issue by issue. So I direct you to that. Focusing here on two illustrative issues, the Mufti letter, remember that letter of the 19th of January 1997, signed by good Mr. Mufti, and good faith. As I noted earlier, the tribunal viewed the Mufti letter as a very strong indicator that Pakistan considered itself as a party to the Dallah Trust Agreement. And that's the slide which you currently have. That's another quote from the award. The tribunal's overarching conclusion is on the next slide. And you see that it says that Dr. Mahmasani believes that when all the relevant factual elements are looked at as a whole, they constitute a comprehensive set of evidence that may be relied upon to conclude that the defendant is a true party to the agreement with the claimant and therefore a proper party to the dispute that has arisen with the claimant under the present arbitration proceedings. And again, note the reluctance in the final paragraph from Lord Mustell and Dr. Shah, who yet join in the conclusion. Dr. Mahmasani also went on to say, but there he was on his own, that the GOP was also bound applying principles of good faith. Dr. Shah and Lord Mustell rejected that analysis. They did not agree that a duty of good faith could operate, I quote, to make someone a party to an arbitration who on other grounds could not be regarded as such. Ultimately, the tribunal reached a unanimous view having regard to, I quote again, the general justice of the case. Tribunal then went on to render a second partial award on liability in favor of Dallah and an award on damages of some $20 million, damages and costs of some $20 million, that was rendered on the 23rd of January 2006. So, we're now 10 years after the lapse of the trust. Dallah finds itself finally with the monetary award of $20 million against Pakistan in its pocket. Before we move to consider that award's fate in our two cities, London and Paris, we should pause to make some tactical considerations. Following receipt of the award, Pakistan had to decide whether it wished to apply to have it set aside in France. It chose not to do so for reasons which I think will be obvious. And the matter, just so you know, was addressed by Lord Justice Ricks in the English Court of Appeal, dealing with an argument raised by Dallah saying that this constituted some sort of waiver or estoppel. Lord Justice Ricks would have, unsurprisingly, none of that and held that Pakistan was under no obligation to challenge the award in France. Fine. Pakistan could do what it wanted, but Dallah could have forced the hand of Pakistan. How? They could have forced Pakistan to litigate the fate of the award in France by, one, filing an application for the enforcement of the award in France, which would in all likelihood have prompted, two, an application by Dallah to set aside the award. Why am I so confident that this is what French law does? Because that's in fact what happens later. Because that's what Dallah ends up doing, but too late. Instead of doing it at the outset, it only does so after both Mr. Justice Aikens and the English Court of Appeal have rendered their judgments. Specifically, the application for enforcement in France is made on the 19th of August 2009. In response, as could be expected, on the 21st of December 2009, Dallah applies to annul the award, so now the fate of the award is live in France. Then Dallah goes to the Supreme Court. We're all the way up at the Supreme Court on Dallah's own action to enforce the award and says, please stay the proceedings, the French courts are now going to decide that. Of course, the Supreme Court refused, just as a matter of efficiency of the proceedings. And Lord Mentz addresses that in his judgment and says, since Dallah has chosen to seek to enforce in England, it does not lie well in its mouth to complain that the government ought to have taken steps in France. So, following receipt of the award, Dallah accordingly made not one, but two momentous tactical decisions. First, by not taking any steps in France, a jurisdiction where the award clearly stood better chances of being upheld. And secondly, by actively choosing to take steps to enforce in England and Wales, thus bringing the awards before courts which were, on any view, less likely to uphold the award. And this is all the more important given that we know, because Lord Mentz said so on many occasions, but most notably in his Freshfields lecture of 2015, and I quote, that if the decision of the Paris Court of Appeal had preceded that of the UK Supreme Court, it would have received the closest attention. So, by proceeding as it did, Dallah may have done no favors to its chances of success, but very luckily for us, we can now discuss this case. Now, thanks to Dallah, the post-award saga thus starts not in France, but in England and Wales. It starts with a without notice application before the English Commercial Court. That's made in July of 2006. The matter comes before Mr. Justice Aikens. Now, a word about Sir Richard Aikens, as he now is. He was one of England's foremost commercial judges and was promoted to the Court of Appeal in 2008. He's delivered judgments on key issues. He was the judge to hear the first investment case that came before the English courts. He truly is a tremendous legal brain. He's now a sought-after arbitrator, continues to be much involved in shaping English arbitration law. Indeed, I'm currently working with him on the reform that is taking place in England on the Arbitration Act, and we're making submissions to the Law Commission on the effect of ENCA, which is a related decision, which I will come to later tonight. So a full rehearing of the issues of jurisdiction de novo took place before Mr. Justice Aikens. As a matter of English private international law, I apologize if many of you know that, but it is important for those of you who don't, because that's English effectively procedural law. As a matter of English private international law, expert evidence on foreign law is received and treated as fact. That is not law, not something which one can review on appeal. And for the purpose of the full rehearing before him, Mr. Justice Aikens thus had the benefit of oral and written evidence from expert witnesses on French law, this being the putative law applicable to the arbitration agreement under Article 5.1b of the New York Convention, as implemented in English law under Section 103.2b of the Arbitration Act. So expert evidence on French law, also expert evidence on Pakistani law, because that to deal with issues of capacity and issues of succession of the trust. On French law, again, Ali is ahead of me. You will recognize these faces well, I'm sure. Maître Yves de Reims needs no introduction to this audience. He was the 2013 Berthold Goldman Lecturer. And Monsieur Le Bâtonnier Vattier is an equally distinguished French lawyer and former president of the French Bar. Again, I don't have the time to go in the intricacies of how the evidence of French law developed before Mr. Justice Aikens. First, by way of written reports. Then the procedure is that the experts meet and produce a joint memorandum, which normally is not that useful, but in this case turned out to be quite useful to the court. And then, of course, there is cross-examination of an oral evidence. The key points to note on French law as adduced before Mr. Justice Aikens are as follows. First, the experts were agreed that it is open to an international tribunal, the seat of which is in Paris, to find that the arbitration agreement is governed not by national law, but by transnational law. No surprises there. Secondly, the experts were agreed, and that's our next slide, as to this, which is again the test you would come to expect coming from French courts as to where you find whether someone, a non-signatory, is bound or not. But thirdly, and very importantly, both experts further agreed that when the court is looking for the common intention which is referred to here, of all the potential parties to the arbitration agreement, it is seeking to ascertain the subjective intention of each of the parties that was put to Maître de Reims in cross-examination and accepted by him. And so, if you pause here to think about what's going on, the evidence of French law before Mr. Justice Aikens thus led to a test quite different from that applied by the tribunal. Instead of an objective test where the factual elements of negotiation, implementation, and termination of the contract are taken into account to deduce an objective implication of the third party, which is then followed by, in truth, quasi-automatic presumption of consent, the test was framed before the English court as one which went to common subjective intention. Indeed, while Maître de Reims had framed the test in objective terms in his written report by reference to the formula used by the Cour d'appel de Paris in ABS, he accepted in cross-examination that that expression of the test by the Paris Cour d'appel did not detract from what was put to him as being the basic quest, that is, to find the common will of the parties. Consistently with this, Mr. Justice Aikens described the exercise that he had to undertake as follows. So what is he looking for? He's looking for subjective common intention. He carried out a full and independent analysis of the facts, undertaking that in the same order as the tribunal, negotiation, signature, performance of the agreement, etc. Again, I can't do justice to that, and I refer you to Jacob's table in his article. Focusing for present purposes on the two illustrative areas I referred to when looking at the award, with respect to the letter from Mr. Mufti, that letter of 19th of January, Mr. Justice Aikens had quite a different take on the letter, which you find on slide 18. And then, once you've read that, perhaps you'll move to slide 19. In effect, what he's saying is, Mr. Mufti, on the 19th of January, when he's writing this letter, has no idea the trust has been, is no longer. How do we know that? Because the next day, he's filing an action before the Pakistani courts in the name of the trust. And he signs that plaint, and he supports it with affidavit evidence. So to an English judge, that means that letter is clearly a letter that he's purporting to write as Secretary of the Trust. Now, with respect to good faith and but you can see obviously a very different conclusion from the tribunal. With respect to good faith and transnational law, he gave very short shrift to this ground. He concluded that transnational general principles and usages and the tribunal's reference to these principles reflecting the fundamental requirements of justice in international trade had been left on a high level of generality, and he could not see what this added to the task that he had to undertake. His overall conclusion is on the next slide. Again, look at what he's looking for and what he finds. He's looking for the subjective intention of all parties. So he has used the factual matrix to look for subjective common intention. Thus, applying a quite different test, one, as I just said, where the factual elements showing the implication of Pakistan were to be used to discern the subjective intention of Pakistan, rather than an objective one where Pakistan would be presumed to be bound from those elements, Mr. Justice Aikens reached what I respectfully submit was a foregone conclusion, that Pakistan did not subjectively intend to be bound by the agreement. It didn't. And we'll come to that as this lecture progresses. But note what happens. Dallah then appealed to the Court of Appeal and lost, and then to the Supreme Court and lost. Again, I don't have the time to cover the detailed analysis, much more detailed actually in the Supreme Court than in the Court of Appeal's judgment. The key point is one I made earlier, which is that, as could be expected, the Court of Appeal would not interfere with the findings of fact, for that is what they were, of Mr. Justice Aikens. And remember, the findings on French law, which in any event were really common ground, they could not come back on. These were, for the appellate courts, findings of fact. And you find that on the next slide. This is Lord Justice Moorbeek, another very distinguished commercial judge. And on a paragraph which is not on this, which I will read to you now, you again see the task that the English courts were carrying out. He says, it is important to recognize that the judge, that's paragraph 28, not only had the benefit of hearing the witnesses give their evidence, but also had the opportunity of clarifying with them through direct questions his understanding of the relevant principles of French law, an opportunity of which he took full advantage. Having seen the evidence before him, I am of the view, so Lord Justice Moorbeek is of the view, that it fully supported his finding that French law is concerned to ascertain the real or subjective intentions of the parties in order to determine whether an agreement existed between them. So again, subjective test. Before crossing the channel to France, let me say a few words about the bench which heard Dallah's appeal in the Supreme Court. I won't be looking at what they said on the facts, but we are going to look at some of their legal reasoning in the next part of this lecture. And I think it's a word that's always used, but truly that bench was a formidable bench. I shouldn't say anything about that. I won't say anything about the current composition of the Supreme Court, for I probably will have to appear before them soon. But this really was a time when there were 5 high-caliber commercial judges with real arbitration experience on the Supreme Court. Lord Hope was the Deputy President. He was the Scottish law lord on the bench. He was the judge who gave the judgment with Lord Hoffman, for example, in Fiona Trust on separability. Lord Mence, who gave the lead judgment, was one of the leading commercial barristers of his generation. He gave judgments in West Tankers, Occidental, Dardana and Newcastle Oil. He has incredibly vast comparative law expertise, including very detailed knowledge of civil law, more German law than French law, but also knows French law very, very well indeed. Lord Saville was one of the main drafters of the English Arbitration Act. Lord Collins needs no introduction to anyone who practices conflicts of law. He's the author of what used to be known as Dicey and Morris. It had been known as Dicey and Morris for a century until he came along, and now it's Dicey, Morris and Collins. He's really a force. And Lord Clark, a very, very distinguished commercial lawyer. Now, following the dismissal of Dallah's appeal by the Supreme Court, all eyes, of course, turned to the French courts. Academics, practitioners, and students of international arbitration eagerly awaited the outcome of the courts in Paris. In fact, the international arbitration community knew all too well that the Dallah Award would lead the French and English courts on a head-on collision course, and that's exactly what happened. The outcome from the Paris Court of Appeal was diametrically opposed to that of the English courts. As is usual for French judgments, the Cour d'Appel's judgment is much briefer than that which all 3 English courts delivered, but that is simply the way French judgments are drafted. For the Paris Court, taking the elements in turn, the fact that the pre-contractual negotiations were led and driven by the government of Pakistan was a strong pointer that Pakistan wished to be implicated in the contractual arrangement with Dallah. Ali, go back one slide, thanks. Regarding the implementation of the agreement, the Paris Court laid emphasis on 2 pieces of evidence, 2 letters sent by Pakistani officials, which none of the English judges, save for Lord Mence, even considered, and then Lord Mence simply found it to be irrelevant. Unlike the English courts on the creation of the trust, the French courts did not regard that as an instrument by which Pakistan sought to distance itself from the contractual arrangement. For the English courts, there was an MOU. That was with you, Pakistan, and then there's a deliberate decision to have an agreement with another entity. You're distancing yourself from government. But not for the Paris Court of Appeal. On the contrary, they held that the creation of the trust had been purely formal and that the government had behaved as a real Pakistani party in the economic transaction. On the Mufti letter, they take a completely opposite view. They don't take into account the context which is taken into account by the English courts of the action being started the next day. This is a government of Pakistan letter being sent by the government of Pakistan, and therefore you are bound. And they conclude and that is the slide we were looking at earlier, slide 25. I would have loved to do that for every French quotation I'm going to make tonight. I apologize in advance to English speakers, but there will be some French as we go down the line. We'll find a way to let the students in particular have translations in due course. Now, note the test applied by the Cour d'appel. Unlike that applied by the English courts on the basis of the French law evidence that was adduced before them, before the English courts, this is an objective test. The Paris Court of Appeal analyzes the factual record to assess what? To assess whether Pakistan has acted as, s'est comporté comme, the true party to the agreement. As it had done so, there is no further factual inquiry, but did you mean to do that? You did it. You did it, you're bound. Presumption, we'll come to presumption in a moment, but you did it, you're bound. That is what the Paris Court of Appeal does. Such is the tale, narrative tale, of this striking case in our two cities. Following the issuance of the French judgment, passions truly were unleashed. How could the French and English courts reach such diametrically opposed conclusions on the same question applying the same law? Much ink was spilled in each jurisdiction by commentators seeking to defend, inverted commas, their courts, their judges, and their conception of international arbitration. Lord Menz and our regretted Emmanuel famously came to clash in a grand débat in the Court of Cassation in 2017. Now that the dust has settled, what lessons can we truly learn from the case? What is the legal legacy of Dallah? As I noted in my introduction, I would like to answer that question by reference to two key legal issues. First, the standard of review to be applied by courts when considering issues of jurisdiction. And secondly, the question of the law applicable to the arbitration agreement. Starting with standard of review, the court in both jurisdictions found that a court faced with an issue of jurisdiction must conclude a de novo rehearing of the relevant issues. So absolute uniformity from courts on both sides here. This orthodox solution, which gives its legal expression to the common sense proposition that what? Three persons sitting in a room cannot confer upon themselves a jurisdiction which they don't otherwise have. Or to use the accepted colloquialism, they cannot pull themselves by their own bootstraps. And that really should be the lasting legacy of Dallah. And I wasn't going to say very much at all about this tonight. But in fact, it is under attack in both jurisdictions at the moment, and therefore a word does need to be said about that. Starting with English law, the rationale is very clearly spelled out by Lord Menz, Lord Collins, Lord Saville, in the judgments, in very detailed comparative law analysis. And that is also one of the legacies of Dallah, which is it's one of the first judgments where really you see the English court all the way at the level of the Supreme Court engaging with a very detailed analysis of US law, French law, other laws to try and find solutions. So the shortest exposition, and that's simply why it's there, is that of Lord Saville's. It's not less cogent for its brevity. It's set out on this slide. Now, the recent statements of all three law lords in Dallah have long been settled law and should not be controversial. Yet, as I said a moment ago, they are under attack. In previews of the consultation paper, which it expects to publish this September on the reform of the Arbitration Act 1996, the Law Commission of England and Wales has indicated that one of the areas which it is thinking of reforming is this settled rule, on the basis that it allegedly gives parties challenging jurisdiction two bites at the cherry. The proposal will apparently be that if a party has participated in the arbitration and has challenged jurisdiction, then Section 67 of the Act, which is the gateway for jurisdictional challenges, should provide a basis for an appeal, but not a de novo review or challenge. If a party, therefore, wishes to challenge jurisdiction, you must choose. You either do it before the tribunal or you do it in court, but you can't do both. Now, this proposal fails to engage with the fact, which has been incredibly cogently analyzed on this side of the channel, in particular by Emmanuel, in many writings, that the rule of competence is simply a rule of temporal priority. You cannot remove from the courts the role of finally determining issues of jurisdiction. So a pushback against this proposal is accordingly being organized on our side of the channel, starting with a conference that we're organizing on the 13th of October, at which many, Pierre Mayer, Christophe, will be joining us, because I think it's very important for the Law Commission to see the comparative law angle to this and to see that if they do that, while they don't realize it at all, they would come out completely out of step from what other jurisdictions, all the developed jurisdictions, have been doing. Now, turning to French law, the position was pithily set out again by Grierson and Tauk in their commentary on Dallah, and that's the next slide. And none of this should come as a surprise to any of you who have any French law, citing pyramids, citing Abela, which is pyramids the other way around, so a negative declaration of jurisdiction. Exactly the same rule applies in France as it does in England. But that rule appears to be, and there I speak with more diffidence, and you will have to judge for yourselves whether there is a risk there, or whether I'm mistaken. But it does seem that the rule is equally at risk, but this time the other way. Whereas we are in danger of restricting the rule, it seems that there is a risk here of widening the purpose of a de novo hearing beyond its proper remit. I'm talking, of course, of the recent decision of the Court of Cassation in Schuna, which appears to have opened the door for parties challenging jurisdiction to raise new jurisdictional arguments before the annulling court, even though they could have brought those before the tribunal but failed to do so. And this does seem to be going too far, and I wonder whether a comparative law approach, this time the other way around, looking at what, for example, we are doing in England, might bring the Court of Cassation back to what I would respectfully submit is the right line. Because it's been long established in England that while, of course, a challenge to jurisdiction is a de novo rehearing, the equivalent legal provision to your Article 1466, which is our Section 73 of the Arbitration Act, does apply to preclude the raising of new objections that could and should have been raised before the arbitral tribunal. Now, that does seem to strike the right balance, and it would be interesting to see how matters develop in that respect in France. So much for standard of review. I now turn to address the second legal issue, applicable law. On the face of it, the courts in both jurisdictions apply the same rules to the issue of jurisdiction, rules designed by the French courts. But two issues arise for discussion. First, obviously, the question of why the courts in England and France reach opposite conclusions despite their purportedly applying the same law. I think you will have an inkling as to what I think the answer is, but I'll come to it in a moment. And secondly, and that to me is the most interesting, that of the methodology used by each court to determine what rules would apply. And I'm referring, of course, to the familiar debate regarding conflict of law rules and règles matérielles, which was and has remained a central point of focus in discussion of this historic case. Let me address these 2 points in turn. First, why did the courts in England and France reach opposite conclusions despite their purportedly applying French law or rules of law? I believe the correct explanation for this was provided in characteristically lucid terms by Pierre Mayer in an article written in the wake of the English Court of Appeals judgment in 2009, which he then reiterated in an article published in 2012, and which was cited with approval by Isabelle Michoud in her note on the Supreme Court's and the Paris Court of Appeals judgments. As we have seen, the evidence of French law adduced by both parties before the English courts led those courts to apply a test based on a search for the common subjective intentions of the parties. But as noted by Isabelle Michoud, and there I do apologize, it's in French, so if you've got a French speaker next to you, perhaps he can whisper or she can whisper in your ear. Le professeur Mayer, commentant la dernière jurisprudence française dans un article récent de 2009, a résumé celle-ci en ces termes. Pour qu'un individu ou une société soit lié par une clause d'arbitrage, son comportement n'a pas besoin de révéler son consentement d'être lié, mais exige seulement que l'individu ou la société soit informé de l'existence et du champ d'application de la clause d'arbitrage et qu'il soit directement impliqué dans l'exécution du contrat et dans les litiges qui peuvent en résulter. Être impliqué, même directement, ne signifie pas nécessairement consentir à être lié. L'effet obligatoire ne repose pas sur un consentement tacite, il repose sur une situation objective, le fait d'avoir été impliqué. I will translate just that bit for the English speakers. Being implicated in a transaction is not the same as agreeing to be bound by that transaction. The binding effect rests not on tacit consent, but on an objective assessment, the fact that you were implicated. Thus, the way the expert evidence was put before the English courts gave those courts the opportunity to do what? Simply to revert to type. That's what English courts do. They spend their life looking for common subjective intention. When they were told that's the test, they did it. Of course they would. But why was that door left open? It was left open by the French courts, as explained by Pierre Mayer in his articles, since their own jurisprudence was ambiguous in that respect. ABS seems to put down an objective test. You've got other cases that talk about presumed or implied consent. So where does the ambiguity in French law stem from? And the answer seems clear. It arises out of a reluctance to let go of consent as the nominal justification for what is in truth a policy-based rule. Emmanuel Gaillard recognized as much in his note on the Coup-de-Foudre Kababji case, the famous note on the vertu de la méthode des règles matérielles, where he noted that the rule had to be framed as a rebuttable presumption, because to do otherwise would be to go against the consent-based foundation of arbitration. And I'm sure this will be very familiar to most of you, but this is what he says. We must say it's consent, because otherwise, what's the basis? And Jean-Baptiste Racine goes in the same direction. That's the next slide. And his conclusion, I'll just read the final words in bold here. Faire référence à une présomption d'acceptation de la clause d'arbitrage est justifié. C'est en cela que le fondement contractuel de l'arbitrage, and note these words, n'est pas sacrifié. So you must do what? I'm sorry, I'm putting words in his mouth, that's not what he's saying, but you must pay lip service to consent. You can't sacrifice consent. Other authors are more transparent about the true nature of the rule. Thus, Fadlallah and Asher, and that's our next slide, actually say it in terms. La référence à la volonté s'explique pour respecter le fondement contractuel de l'arbitrage, mais ce n'est plus que cosmétique, car la volonté est induite quasi automatiquement de faits objectifs. On invoque un fondement subjectif, mais on applique une règle objective. Philippe Pinsol, next slide, says the same thing. With the exception of subcontractors, the French approach is therefore firmly grounded on an objective test based on the participation in the performance of the contract without any reference to the arbitration agreement itself. As Professor Brikoulakis remarks, such an approach is very difficult to reconcile with fundamental principles of consent. Some French authors have pointed out that when courts still applied the subjective approach, they were in essence creating consent by way of a double presumption, and you will recognize that double presumption. So, the way in which Pakistan was able to portray the applicable rule of French law to the English courts, very cleverly, if I may say so, thus stemmed from an ambiguity in the jurisprudence of the French courts, which itself stems from a more fundamental ambiguity as to the very foundation of the rule, consent or policy. And that dichotomy is at the heart of the second legal issue, the methodological debate on applicable law, which I now turn to address. The question of the methodology by which each court reached the conclusion that rules of law devised by the French courts applied to issues of jurisdiction raises important theoretical and practical issues. In England, the analysis was very simple. In default of contrary agreement by the parties, the courts were mandated by Section 103(2)(b) of the Arbitration Act, which implements into English law Article 5(2)(b) of the New York Convention, to apply, I quote, the law of the country where the award was made. That is, French law is the law of the seat. That's a conclusion which one would hope every New York Convention country would come to, save if, like in France, it's used Article 7 to introduce a more favorable regime. Now, in France, the test applied is said to be a règle matérielle de l'arbitrage international, a substantive rule of international arbitration. The debate thus revolves around the nature of these règles matérielles. In the English Supreme Court, Lord Mentz addressed that question at paragraph 15 of the judgment. After referring to the Dallah formula, he said this, and that's our next slide. Cour de Cassation is a national court, giving a French legal view of international arbitration. And Dallah and the government agree that the true analysis is that French law recognizes transnational law principles as potentially applicable to determine the existence, validity, and effectiveness of an international arbitration agreement, such principles being part of French law. And Lord Collins, as you would expect, comes to the same conclusion. And they cite the very well-known passage from Poudret-Besson, where Professor Poudret made that point many, many years ago. Now, it's not entirely clear to what extent transnationalists like Emmanuel Gaillard or Professor Fadlallah or Judge Asher on this side of the channel, whether they would disagree with the characterization of the règle matérielle as being rules of French law. Where there clearly is strong disagreement is with the notion that they can still be assimilated in any way to rules of conflicts of law, right? And this was expressed by Emmanuel as follows in his note on coup de foudre. So he explains first the message, which you will all be familiar with. C'est la solution que donne directement la règle. And then he says, and these are the important words, même si cette règle matérielle appartient au droit français de l'arbitrage. So he does say it is a rule of French law, so there's agreement there. On se gardera de penser qu'il s'agit du produit de l'application d'une règle de conflit désignant la loi du siège pour régir la question. La règle matérielle est en effet applicable dès que les juridictions françaises sont saisies du litige, même si le siège de l'arbitrage ne se trouve pas en France, etc. C'est donc bien d'une règle matérielle dont il s'agit, abstraction faite de toute règle de conflit. So, what he says is that, well, it's not a rule of conflict of laws because we in France apply it whether you're looking at setting aside of an award rendered at the seat or at enforcement of an award rendered abroad. So you can see, looking at Lord Benz, Lord Collins, and what Emmanuel Gaillard says, that there's a very stark division as to the very nature of the exercise. And we are at risk of falling here into our Dickensian stereotypes. French exceptionalism against English pragmatism. And it's a stark division that has often given rise to, I would submit, unhelpful language and unhelpful irony on both sides. Lord Menz could not resist it. If you look at paragraph 18 of the judgment, there is irony there. In his recent article on coup de foudre, Emmanuel could not resist it either, accusing, for example, the conflictualists of hypocrisy. I respectfully submit that this is a sterile debate. Is there a way, and what we ought to be looking for is that way, to go beyond such divisions? And I would respectfully propose an answer given by none other than Lord Mustill, who, as you heard, was later to become one of the arbiters in Dallah, at the time when the English Arbitration Act was passed. That's what he wrote in the companion volume to Mustill and Boyd about what the Act had done to English arbitration law. Conceptually, he says, the Act marks a radical change of direction. No longer are the internal rules to be derived by analyzing the contracts between the parties inter se and between themselves and the arbitrators. So pause there for a moment. Conceptually, we're no longer looking at consent. We're no longer analyzing the contracts and nothing else. The arbitral process is still consensual to the extent that the proceedings would not take place but for the agreement to arbitrate. But by making this agreement, the parties contract into a framework not chosen by themselves but imposed by Parliament, save only to the extent that they avail themselves of the opportunity to depart from the semi-mandatory provisions. Now, and there, I'm going to put my hard hat on and expect lots of criticism from our French colleagues, but I would venture to propose that the same can be said, mutatis mutandis, of the contemporary French law of international arbitration, and that you, French practitioners, academics, and judges, would actually benefit from seeing matters in that way. The web of règles matérielles being created, ironically, in a code-based civil law system by the French courts, is in truth a pro-arbitration legal framework which the parties opt into whenever they choose international arbitration as a means of dispute resolution. And that framework will come into operation whenever an international arbitration comes into contact with France. I will come back to this proposal in a moment, but in order to make sense of it, I think we need to do that against the correct background. So I'm going to spend a few minutes talking about what the French courts are really doing when they are developing these règles matérielles. Now, this is a complex and vexed question, and I would accordingly ask you to bear with me as I address it. So I'll try and make this easy to tell you exactly how it's going to pan out. I'm going to make 5 points and make one proposal in conclusion. The first and starting point is a short one. It is that when they are developing these règles matérielles, the French courts are clearly stating rules that will apply in France. That's the run of their jurisdiction. Nothing more, nothing less. Next, and that's my second point, is it, however, true to say that these règles matérielles are not rules of French private international law? As we have seen, the answer given by those that take that view is that they are not, because they apply uniformly whether you're looking at a challenge to an award rendered in France or to a challenge to enforcement of an award rendered outside France. Now, and I'm wearing my foreign lawyer's hat, but this is very unlikely to convince someone outside France, because the response will simply be that France has decided to apply the same rule of conflict of laws, both to challenges, to awards rendered in France, and to awards coming for recognition and enforcement. And the reason we would find that absolutely natural is that, as you can expect, most jurisdictions have the same rule. It would be a very odd jurisdiction that would say that it's going to adjudicate on consent one way on a challenge and another way on the New York Convention. And that's been reconfirmed very recently in so many words by the Supreme Court in England and Wales in Enka. So that is, again, with respect, not a terribly convincing argument. My third point is that one further problem faced by those that would see these règles matérielles as being entirely outside the realm of conflict of laws is the Unicode decision of the Cour de Cassation. That decision, which you will, I hope, all be familiar with, otherwise have a word with whoever's teaching the course on the Academy this year, but I don't have the time to explain it. But what it does is makes it plain that the parties remain in principle free to choose a national law to apply to their arbitration agreement, right? So the Court of Cassation says that. If that is so, then one is indeed dealing with the rule of conflict with one, a default rule in favor of French judge-made règles matérielles, but which can be displaced by two, a contrary choice of national law made by the parties. That does look very much like a conflict of law rule. Now, the existence of the Unicode exception has recently been reaffirmed by the Paris Court of Appeal in Coup de Foudre, as noted by Jean-Baptiste Racine in his comment on the decision, and that's slide 36. As la Cour se place dans le sillage de l'arrêt Unicode, elle confirme à ce titre le caractère supplétif des règles matérielles qui s'appliquent normalement dès lors que le siège est en France, la Cour précisant que ces règles étaient applicables au siège de l'arbitrage expressément désigné par les parties. Elles s'appliquent, sauf volonté contraire des parties, sur la base d'un système d'opting out. So, it does look that this is currently very much French law. And that's important to bear in mind when I come to the next point, still on my third point, still on Unicode. The difficulties which the Unicode exception poses to transnationalists are manifest from what appears to have been an ongoing debate between Professor Dallah and Judge Asher on the one hand, and Emmanuel Gaillard on the other, as to what is to happen in this situation where the parties have chosen a national law, so you are within the Unicode exception, national law will apply because the parties have chosen it. Normally it will have to be in the arbitration agreement, but that's what's posited. But that law would invalidate the arbitration agreement. What do you do then? In that situation, Professor Dallah and Judge Asher are of the view, I quote, that la référence à une loi invalidante ne peut l'emporter sur la règle d'autonomie. So you disregard the choice of the parties and you apply autonomy. Professor Gaillard marked his disagreement with that position in his comments on the Coup de Foudre Kamabji case in terms which I think are very elucidating of the whole position. He says this. Il est vrai qu'une clause faisant le choix express de faire régir une convention d'arbitrage par une loi qui l'annule serait sérieusement pathologique. De ce fait, la tentation serait grande de faire prévaloir la volonté de recourir à l'arbitrage sur celle de voir la convention d'arbitrage soumise à un régime précis qui l'annule. Il nous semble cependant qu'en cas de conflit frontal entre la volonté des parties et le principe de validité, que la considération des circonstances de la cause ne permettrait pas d'éviter, la première devrait l'emporter sur le second. And look at these words. L'essence même de l'arbitrage réside dans le respect de la volonté des parties et il serait paradoxal que l'esprit de faveur à l'arbitrage puisse aller jusqu'à faire du principe de validité de la convention d'arbitrage un principe d'ordre public l'emportant sur la volonté des parties. So what Emmanuel says consent, of course, must come first. Otherwise, how do you justify the whole construct? So it's always open to the Court of Cassation to follow the recommendation of Professor Dallah and of Judge Asher and to get rid of this conceptual problem by overruling Unicode. But at what cost? That of party autonomy. To do so would be to recognize openly that the French règles matérielles are in fact not based on party consents, since the parties' consent to apply a national law to their arbitration agreement would be ignored, but on a policy choice in favor of international arbitration. I'm not suggesting for 1 minute that that is not a valid policy decision for the French courts to make, only pointing out that it would be a policy decision, not one based on consent or party autonomy. So that was my third point, Unicode. Now, my fourth point consists of a concrete example. What law should a tribunal seated in France apply when confronted with an issue of jurisdiction? If one follows the idea of an ordre juridique arbitral, the tribunal should have great latitude, the greatest latitude in that respect. Is that true? As we saw in Dallah, the tribunal in fact applied a test that was derived from French law. In the recent case of Kababji, Bruno Laurent, very experienced French arbitrator, in terms applied French law on the basis that that is the law that the courts would apply on an annulment. And the matter, very lucidly, is put in those terms by Professor Racine. That's the next slide. Certes, un tribunal arbitral siégeant à Paris n'est pas formellement tenu par les règles matérielles françaises, il est libre de la méthode de détermination du droit applicable. Mais il y est fortement incité dans la perspective d'un recours en annulation. And then he goes on to say, and it's going to be a full rehearing, so you'd better do it. So ultimately, a tribunal seated in France is going to have a major incentive to apply the règles matérielles, French law, particularly given its obligation to render an enforceable award. Now, my fifth and final point relates to a further issue with the règles matérielles approach, which is perfectly crystallized in another passage of Emmanuel's note on coup de foudre. In dismissing the views of authors such as Christophe Seraglini and Jérôme Ortscheid as to the alleged disconnection of the règles matérielles from all national laws, including French contract law, Emmanuel noted that there must be limits to consent and that situations may arise, where the courts will have to decide whether a purported consent has been vitiated by error, fraud, duress. But he goes on to say that assessment must take place without reference to any national law. And that's effectively what this passage says. He recognizes that openly, as was his wont. He lucidly goes on to see what his method leads to. Now, every civilized system of contract law is based on party autonomy and on consent. It is thus entirely uncontroversial for the French courts to place this at the center of their règles matérielles. Of course. But it's also not enough. Every civilized system of contract law has had to devise legal rules to deal precisely with the issues that Emmanuel refers to: error, fraud, duress. That is why the French Code Civil contains an entire section on the vice du consentement. Now, it's entirely open to the French courts to say they will not apply these rules. Fine, they won't open the Code Civil, they will not apply these rules. But one then must be honest as to what the consequence is. The consequence is that one is handing over to the courts the task of developing new rules on a case-by-case basis to deal with alleged vice du consentement. Right? Welcome to the common law. And now to my conclusion and proposal. Should these 5 points mean that one should rebuff the French court's claim of transnationalism on the basis that these règles matérielles are nothing more than what the French courts and the majority of the French legal community consider to be transnational rules? Should one go that far? I believe this is going too far and is unnecessary. It's going too far because one must recognize that there is a true search by those involved in developing these rules for international norms that would best serve the interests of international arbitration. One may disagree with specific solutions put in place, but that is clearly the intent behind those rules. And it's unnecessary, because such a stance alienates and prevents dialogue. In that respect, it is very important, and that is an argument I make regularly to our friends on the other side of the channel, to remember, in my humble view, that French theorists and French law have led the way on many central aspects of international arbitration which are now accepted by all, but which were once controversial. There are many, many examples. I'll just take one. Separability, the Arrêt Gosset, 1963. It takes England 31 years to catch up in Harbour and Kensal, and then it becomes Section 7, and then it becomes Fiona Trust, and it's now all uncontroversial. But if France had not led the way, would we now be here? And French law remains at the cutting edge of potential new developments. The decision in Nayok and Israel, where the French court stepped in to appoint an arbitrator to avoid a denial of justice in the face of a breakdown of the appointment machinery, is another example in point. Again, you may agree or disagree with the solution, and every jurisdiction will be free as to whether to adopt it or not to adopt it. But I don't think it can be discarded without proper consideration. And it's important to recognize that such solutions could not arise without a theoretical underpinning, without the theories devised over the years by many in this jurisdiction in France, from Berthold Goldman to Philippe Fouchard to our much regretted Emmanuel. Respectful dialogue with those great thinkers and those that follow in their footsteps is what we need, not acerbic dismissal. A dialogue and respect, I hasten to add, which should go both ways. The correct question, therefore, is not, or should not be, what separates us, but what it is we have in common and what it is we can do to defend and foster that common ground. Ultimately, both our jurisdictions, both our cities, are seeking to facilitate the fair and efficient resolution of international disputes. In a word, to be safe and efficient arbitral seats, and to lead the way for other countries that share that objective. Importantly, in today's world, this means taking active steps and making pro-arbitration policy choices to avoid interference by foreign courts and foreign laws that may not have such a pro-arbitration stance. What can we do to foster greater understanding of our mutual systems and to find a common principle stand while respecting the differing theoretical underpinnings of the two systems? And I come back to the quote I showed you earlier from Lord Mustill. Ali, perhaps we go back to slide 35, I believe. And you have it before you again. What does this mean? In other words, what Lord Mustill was saying is that party autonomy remains key in ascertaining whether the parties have opted into the pro-arbitration legal framework created by the relevant jurisdiction, but may have to give way to rules set by that legal framework to protect arbitration. As I noted earlier, there is some irony in the fact that this legal framework is largely statute-based in England, a common law country, and largely judge-made in France, a civil law country. But that doesn't matter one bit. Now, why is it important to recognize this and to move away from party autonomy as a mantra? Because dogma and mantras are not conducive to reasoned or practical solutions. Let me give you two examples, one from each jurisdiction. And I promise, I think that's the last bit of heavy law, and then we move on to the conclusion. But just bear with me, because I think it's important this is only going to work if it works in both jurisdictions. In France, you already have the example. I referred to it earlier while we were looking at the root cause, or what I submit was the root cause of the diverging decisions of the English and French courts in Dallah. The fact that there has been ambiguity in the French case law as to whether the rule on third-party signatories was an objective, policy-based rule designed to hold parties who choose to interfere in another party's contract to the arbitration clause contained in that contract, so objective test, or a subjective one based on consent. As we have seen, inter alia from the writings of Professor Fatlala and Judge Asher, the rule, properly analyzed, is in fact a policy-based rule. Now, if that had been openly and clearly recognized without resorting to a fiction of implied or presumed consent, the door would not have been open for the English judges to revert to type. That would have been the French rule. It would have been clear it's a policy-based rule. That's the way we do it. You, English judge, must apply it. In England, now that's a little bit more complicated and won't be familiar to many of you here, but it's not that complicated, actually. And it's a case that is very well known, which is Enka and Chubb. So the issue there has arisen differently, in a different context. In its decision of the 9th of October 2020, in Enka against Chubb, the UK Supreme Court decided, amongst other things, that applying English conflict of law rules, where parties to a contract which contains an arbitration agreement have made an express choice of law to govern their contract, generally, that choice of substantive law of the contract will also govern the arbitration agreement, right? So they had a choice to make law of the seat or the lex contractus, and they chose the lex contractus. That decision to prefer the law governing the main contract to the law of the seat as the default rule in the absence of an express choice of law in the arbitration agreement was, very much like the French jurisprudence dealing with the extension of the clause to non-signatories, expressed in terms of what? Expressed in terms of implied consent. But like the French jurisprudence, it is in truth a policy decision. Reference to implied or presumed consent, I would respectfully submit, almost invariably are. The alleged factual indicators, which to you demonstrate implied consent one way, will be irrelevant to me, and I will look at other factors and tell you implied consent is the other way. That's the beauty of implied consent. You do with it whatever you want. In truth, it is policy. Now, for reasons, so much for what this is doing and the way it's doing it. Now, for reasons I don't have time to go into today, the practical consequence of what the Supreme Court has done in Enka is that now, and I think the market hasn't clued up to that yet, but they will. We'll make sure they do. In every London-seated arbitration with a foreign choice of law, that is in a great number of cases that come to London, whether or not the arbitration agreement is separable, and what effects will flow from that separable nature, if any, now turn not on English law, not on Section 7 of the Act, not on Fiona Trust, but on the foreign law chosen to govern the main contract. So that instead of being able to rely on the clear principles set out in Section 7 and in Fiona Trust, instead of getting what they opted into, if you go back to the Mastil model, which we were looking at a moment ago, the parties, one, will need to ascertain, usually by means of expert evidence, the content of the foreign law on separability, and two, when the chosen foreign law is not arbitration friendly, they will have to live either with a lack of separability or with a curtailed version of separability. That cannot be a desirable result from the point of view of policy or for the continued promotion of London as a safe and arbitration-friendly jurisdiction. And it doesn't appear that the Supreme Court was alive to the consequences of their legal analysis. So I respectfully submit that if the issue had been addressed using the Mastil model, i.e. as a policy issue to be addressed within the legislative framework of the Act and its pro-arbitration stance, rather than as a purely contractual search for purportedly implied intentions, those consequences would have been avoided. Here, as with the French règle matérielle at issue in Dallah, the resort to a fiction of consent actually gets in the way of an efficient and practical implementation of what both our jurisdictions are looking for, the sustained development of a pro-arbitration stance. It would be remiss of me not to mention in that context, and as a potential point against the argument I have just made, the recent and thought-provoking article by Eduardo Silva Romero on the fiction juridique dans le langage du droit français de l'arbitrage, where Eduardo first acknowledges the multiple fictions contained in the semantics of French arbitration law, including the foundational fiction of presumed consent, which is at the heart of the policy-based principe de validité. But two, seeks to defend those on the basis that they constitute both a necessary act of faith, that's the term he uses, an acte de foi, required to protect arbitration, and a construct, he says, of undeniable aesthetic value. These are, as I said, thought-provoking arguments, but they are ultimately siren calls, which I would humbly submit are best avoided. The problems faced by international arbitration are practical problems, which, while they do require a solid theoretical underpinning, will best be addressed if jurisdictions can make an exchange on the choices required on the true and correct basis. Policy where it's policy, consent where it's consent, and not on fictions which can only muddy the waters. As my draft for this lecture was nearing completion, my attention was drawn to an article by Professor Laurent Henès in the most recent volume of the Revue de l'Arbitrage, where it seems to me Professor Henès makes this very point. You will, many of you in this room, be familiar with this important piece, and if you're not, I would encourage you to read it, whether you agree with it or not. It is a quite excellent piece with respect. Professor Henès begins by asking the following question about the principe de validité. This is slide 40. La question est de savoir si ce système est sincère et non purement incantatoire. On veut dire par là si la méthode de la règle matérielle permet effectivement de faire reposer l'efficacité de la clause sur un vrai consentement, ou s'il ne s'agit que d'un paravent masquant à peine la réalité, à savoir que la convention d'arbitrage est efficace parce qu'il faut qu'elle le soit pour des raisons qui lui sont étrangères. He then carries out a survey of the rules applied by the French courts regarding the existence of initial consent, the scope of that consent, and the validity of that consent, and he asks the rhetorical question of whether one can truly speak of consent in that and other scenarios. And this is his conclusion at slide 41. En réalité, n'assistons-nous pas à une instrumentalisation du consentement, une idée de consentement, un concept de consentement qui masque à peine une position politique? In English, you would translate that by a policy decision. La clause d'arbitrage est valide parce qu'il est bon qu'elle le soit. Now, Professor Henès goes on to criticize that position, having earlier warned his reader, and I quote, qu'il est possible que les propos tenus dans son article heurtent certains éléments de la doxa arbitrale française. Now, I have no wish whatsoever to weigh in on that debate. It's one for our French colleagues to resolve, and they're welcome to do that. The point I'm making is a quite different one, which can, I hope, be less controversial, that it will actually assist our respective efforts in promoting the safe operation of international arbitration on both sides of the channel if we move away from consent as a mantra and recognize our systems for what they are, the Mastil model. One, a web of legislative and judge-made rules which parties opt into when choosing international arbitration. Two, which leaves as much room as possible for party autonomy within that framework. But, and importantly, three, which will at times be taken for policy reasons disconnected from consent and aimed at protecting the system of international arbitration. As I have tried to explain, the great benefit of acknowledging this openly rather than continuing to use consent as a fig leaf, comme un paravent, as Professor Henès puts it, is that it will allow the debate to focus on the correct question. What rule should, as a matter of policy, be put in place to cater for a given situation rather than approaching the issue through the false prism of fictional consent? Nor does the Mastil model put in doubt the manner in which the rules are being developed, through the legislature, as in England, or as a web of règles matérielles developed by the court in France. It is indifferent to the method. But it is likely to allow for greater dialogue between the jurisdictions. Why? Because if the rules on both sides of the channel are stated in a manner which is both clear and honest as to their true basis, with no fig leaf sans paravent, it would be that much easier for other jurisdictions to understand them, understand their true rationale, assess their merits, and decide whether, how to follow them. So once the Mastil model is accepted, party autonomy can, I would submit, find its true expression within a modern system of arbitration law. First, as the initial gateway into the system. The framework of international arbitration, legislative or judge-made, will only apply if the parties have opted into it. Consent as the gateway. Secondly, once that gateway is crossed, consent will be required to such extent as the framework allows. In that second respect, while the principle must remain that maximum room should be given to party autonomy, as I said, there will be instances where it will have to give way to policy. And I've given you the, well, to take two examples covered this evening, this can be, on the English side, rules such as separability and competence that should come automatically with the choice of a safe seat with no option to contract out. On the French side, a règle matérielle such as the principe de validité. There is one important respect, however, and that's the last point before I turn to my conclusion. There's one important respect which was engaged in Dallah, where it may be difficult for our respective jurisdictions to find common ground on the current state of the law, assuming that French law does not retreat from its current position, as some, like Professor Enes, would like. It concerns that first aspect of consent, the gateway into the system. Under English law, and I would venture to say, as a matter of logic and principle, that initial consent is key. It cannot be presumed without a search for true subjective intent. And that's been the consistent position of English law. I've given you its latest iteration in Kabab G. What happened in Kabab G is that the parties, Kudfud was trying to rely on law saying, well, if you're choosing a law, you must look for the law that would validate rather than invalidate the arbitration agreement. And they say, and therefore here, in looking to see whether the other party is bound, you should apply that validation principle. And the court says, no, because you're presuming what you must prove. And that's effectively what is being said on that slide. So that's firmly the position of English law. On the current state of French law, it would seem, and I speak tentatively, that this is effectively what is happening in application of the jurisprudence, culminating with Kudfud, but which you can see at play in Dallah in the Court of Appeal. And it is unlikely that an English judge would ever find this acceptable. Which takes me to the conclusion of this lecture, a point identified by all legal commentators in the wake of the Paris Court of Appeal's decision in Dallah, that is the role played in the Dallah case by differences in legal culture between the two jurisdictions. This was, as I said earlier, identified by all commentators as key. I don't disagree, subject to the point I made earlier. It must be appreciated in which way the evidence developed on French law before the English courts. They were told, you can revert to type, and they reverted to type. But they were only, of course, only too happy to revert to type. So subject only to that, of course, there was a key difference. And the real merits problem in Dallah was the fact that a strict search for subjective consent, such as that conducted by the English courts, led to what would seem to be a manifest injustice. Pakistan was allowed effectively to get away with a situation entirely of its own making with complete impunity. There is thus clearly a stark difference of approach on such issues between the two jurisdictions. The approach of French law is one that is based on an underlying principle of good faith and on a strong aversion for any perceived denial of justice. English law, of course, has no general principle of good faith, and even its most closely applicable, closely equivalent principle, which is estoppel, cannot be used to create legal relations. The way we normally put it is you can use it as a shield, not a sword. And English commercial law has long given preference to certainty over justice. And you must understand this. I think many of our French colleagues don't realize that. But this is done with open eyes. And this is done for entirely sound policy reasons. That is, the promotion of certainty in business with a conscious recognition that in 1% or 2% of cases you will get an unjust result. But the idea is you'd rather know that before settle the case, have certainty. That's the choice that English law made centuries ago. It is what it is. It's not going to change. In the same way as good faith is the substratum of French law. Now, these differing approaches were once again at play in the recent Kudfud Kababji saga, where once again English legal formalism and its refusal to act on presumed consent have created another situation of perceived injustice. Although, and someone not involved in the case, it appears to be less stark than in Dallah, for, to my knowledge, no explanation has ever been given as to why Kudfud could not sue its actual contracting party rather than only Kababji. But these issues must not be overstated for two reasons. First, as noted by Pierre Mayer in his note on Dallah and by Jan Paulsen in his book on the idea of arbitration, the very nature of the system established by the New York Convention creates the possibility of one state accepting within its national legal order where another will not, accepting an award within its national legal order where another will choose not to. That's not a sign of malfunction, but a normal incident of the system. And you should note in this jurisdiction that the potential for such conflicts will be increased where a state chooses to depart from the basic regime of the Convention and to put in place a different regime under Article 7. Secondly, and linked to that last point, the Article 7 point, the perceived injustices of these conflicting decisions between our two jurisdictions are not unidirectional. France does not have the monopoly of justice and good faith. To quote M. Giscard d'Estaing, vous n'avez pas le monopole du cœur. Lord Mentz, in his Freshfields lecture, has made a cogent argument as to why the Court of Cassation's decision in Putrabali defeated the basic contractual expectations of the parties in that case and worked a remarkable injustice. Those on the other side of the channel would thus probably agree with Pierre Maillère that the rule laid down by the Court of Cassation in Putrabali and in many prior cases, no recognition whatsoever ever given to an annulling judgment, is too blunt a rule because it does not allow judges to distinguish a legitimate annulment, such as the one in Putrabali, from the illegitimate acts of an overreaching court. Emmanuel, on the other hand, for his part, criticized the developing English approach to the recognition of annulled awards in characteristic terms, saying it rewards cunning favoritism and sanctions clumsy favoritism. Ultimately, as I have tried to show today, the search is a common one for safe and efficient arbitration, protected from intermeddling courts, and that search can only be served by respectful dialogue, engaging with the true basis of our respective solutions and shirking fictions. Here again, I will leave the final words to Lord Mustill. In an article written in 1984, when he was the representative of the UK at UNCITRAL, Lord Mustill reflected on the fact that transnational theories were unlikely to find favor in England, asking the rhetorical question whether this meant that English practitioners could safely ignore French trends and developments. His answer, as you can see, was an unambiguous no. And he concluded the purpose of his lecture has not been to suggest that there is only one possible view, but to offer some thoughts which may help to prompt a more general debate. That has also been the purpose of today's lecture. I thank you for your attention.
Many thanks, Salim, for this wonderful lecture and showing us that there is not just one view, but many thoughts on the subject. Many thanks also to recall us the Dallah case in all the factual complexity and the legal aspects. In fact, it's at the core of all international arbitration issues, as you can see, methodology, conflict of rules versus substantive rules, also implication or consent, the intensity of judicial control. A lot of questions were raised by this case, and a lot of thinking was given by Salim, knowing not only perfectly the English system, but also, as you see, perfectly the French system. We'll see if the bridge over troubled water will be built one day. We'll see. That's for sure that we have common values or common ideas. That's for sure also there are many differences between, and not only on the subject, between the two legal systems on arbitration, and also, as you said, for historical, cultural, legal reasons, and for a lot of centuries. So we'll see, and the future will tell us if it's another tale to bring this, or to be able to build this bridge, or if it will be a reality. Many, many thanks again, Salim, for this wonderful lecture. I invite you now to enjoy the rest of the evening with the cocktail, the garden, the nice weather, and thanks again.